Chronology? Yes. Pardon? Sorry. Yes, I had it done. Thank you. What is your... Do you know, I'm probably not as bad as you guys. But all rise.
Application in the matter of AK Afghanistan and others, and HCP officer and other.
1 second. Sorry. Yes. My Lords, I appear for the appellant with Mr. David Ball. My learned friend, Miss Samantha Broadfoot, Queen's Counsel, appears with Miss Karen Patry for the respondent. My Lords, if I just deal with some housekeeping matters at the outset, just to check, first of all, that the court should have an appeal bundle which runs to 600 pages, a supplemental bundle which includes the tribunal decisions in my client's case. Yes. 2 volumes of authorities. Yes. And then, this may or may not, I think this is for you, also a supplementary bundle of authorities which was filed either yesterday or this morning. Yes. By the respondent. That includes the authorities to which my Lord Justice Lewis helpfully drew our attention yesterday. And my Lord, there's one, the skeletons are included in the appeal bundle, you may have them loose, I don't know. There's one other matter which I asked to have placed on your desk this morning, which is a copy of section 42 of the Adoption and Children Act 2002. Right. Which I'll come to. It's referred to in Mr. Gallagher, the respondent's witness statement, so I'll say something about that in course. Now, there are 2 substantive issues. I mean, I appreciate this is potentially a rolled-up hearing. Yes. But the first is time. Yes. And the second is the substantive issue. Yes. And I think it seems, from our perspective, that it would be appropriate to have the submissions on time first, in both, and then we can review where we are at the end of that. Yes, very well, my Lord. I had proposed to deal with the appeal first, but I'm anticipating you. Obviously, I'm in the court's hands. Yeah, absolutely. Obviously, because we may, No, I take the point. Yeah. I completely understood. And my Lord, on that, actually, strictly speaking, there are 2 time issues. There's the question of delay in relation to the claim for judicial review. There's also an issue about an extension of time for lodging the appeal. But that's, I hope, a more straightforward issue. That's a matter of an extension of 1 day, and I can take you to the witness statements that deal with how that happened. Effectively, there was no legal aid, and there were traffic problems and so forth. And, but I'll deal with both unless you tell me. Do we have any primary documents going to the issue of time in respect of the JR claim? When your Lordship, was there any evidence explaining why? No, there's not. That's not dealt with in witness evidence, my Lord. No.
Well, there's a reference in the High Court judgment transcript to a late application for an extension of time under witness statement at page 416, but it's not included in our bundles. Right.
I confess it's not something I am conscious of. Looking at Mr. President Wilkin. Can I just see if Oh, right. I didn't abide by that. Oh, right, I hadn't picked up on that. Can I take it? Yeah. Right. Well, sorry, it came to mind because you were saying evidence in respect of the appeal extension, but not in respect of the JR. Well, it's not something I was aware of, I should really confess.
It's in the bundle 416. Can we just check that you have the most recent application for an extension of time? And then you ask the judge to go away and receive it. And the deputy judge says, is that one with a statement attached at page 417? So I rather assumed it was an application with a statement, but yes, that's just reading the words on the page.
Yes, I've just been given a copy of the statement. I'm sorry, I picked up on. It sounds like the Respondents' Council can provide the court with a copy.
my lords, would you like to have the application notice and the witness statement?
If you have them, yes,
I do.
please.
I do. Just don't touch it one second.
Yes.
One second.
Well, can I just take a moment to glance at this?
Well, we will too.
Indeed.
When it comes
Indeed.
to us.
Indeed.
Thank you.
Probably.
Thank you very much. Thank you very much. So,
Sorry, my lord, we've also got copies of the order of Mr. Justice Mott.
That would be helpful.
Yeah,
That
which is
isn't in the
also
bundle either. Yeah.
That's right.
that I was aware of, though I confess I hadn't.
Sorry, excuse me. There are more documents to come up.
Oh, sorry, I gave you the top page.
Is there another bit?
There's another bit.
Yeah.
Thank you.
Simon?
Yes, in paragraphs, in paragraph 5,
Yes.
it raises the time.
He raises the time
Direct.
point. He says you'll challenge the wrong decision.
Exactly.
Yes.
And in the paragraph 6, raises the
A separate issue.
the separate issue as to difficult to see why a general challenge to the vagaries of the rules applies
Yes.
to the December 17 decision.
Yes. Yes.
So I think both of those issues need to be addressed.
Yes. Fine. So, just dealing with this material while we've got it in front of us there.
Yes.
The response, in effect, from Mr. Cheng, who was at the solicitor at the time, he's subsequently moved to the government legal department, is I suppose, in paragraphs 4 and 5 of his statement. And he says, picking up on the phrase used by Mr. Mott, you can see that this was I think it is Mr. Mott, not Mr. Justice Mott, as I understand it. That this was a bit disingenuous. Effectively, what's said is paragraph 4 and 5 follow, and I'm going to show you this underlying material in a minute, but you'll have picked up there's a letter in beginning of March saying we're looking into your claim. Please don't bring claim to judicial.
No, it says seeking guidance from the relevant department on your claim, and in particular the endorsement for 33 months.
Indeed. So I'll come to that in a minute, but following on from that, the point that Mr. Cheng is making is that in good faith, effectively, they had understood that to be a fresh decision, and so that was the decision that could be challenged on the 26th, was that of the 26th of April. Now, I don't maintain that submission to the court, i.e. that was correct. I can see that the decision is the decision of December. But insofar as there's but the explanation of why the claim wasn't brought sooner is that they had understood that to be a new decision. Now, that's a mistake on his part, but subject to the court's general discretion and the matters that I'll come on to in a moment, we say it's a relevant explanation of why the claim wasn't brought sooner. Can I then pull back from that specific material and address the issue of JR delay? So, my Lord Justice Lewis has drawn our attention, and I wasn't aware of the authority, to two authorities, but I think probably the critical one is the Badmus case, which is in the supplementary authorities. And I'm not sure if you've got tabs. If you have them, it's tab 4. Badmus starts at page 66 of that bundle. It's a challenge to a rule which applies in immigration detention centres concerning the rates of pay for work undertaken by detainees. And an issue arises in the claim about timeliness, and the court looks at that issue from critically from paragraph 62 onwards, page 82 of this bundle. And the court in paragraph 62 notes the decision of the divisional court in a case called DSD, drawing a distinction between two ways in which a challenge can be brought to delegated legislation. First, there's a decision, the challenge, and just looking at that in this inset paragraph, this is now the divisional court in the earlier case. We agree with the claimants that there is a distinction between cases where the challenge is to a decision taken pursuant to secondary legislation, where the ground to bring the claim first arises when the individual or entity withstanding to do so is affected by it, and where the challenge is to secondary legislation in the abstract. And as I read the judgment, noting that there was no approval of that approach by the divisional court, the Court of Appeal, albeit I think without contrary argument, approves the distinction in paragraph 63 and accepts that that's the right way to look at the matter. And the logic of that is that in what the court calls the abstract category, the challenge does have to be brought within 3 months of the making of the legislation, which is contrary, I quite appreciate, contrary to the way one of the ways we put it in our skeleton. So I can see in light of this...
So do you no longer rely on the decision?
I think I have to say that in those circumstances I need to make a challenge to the decision of December 2017, and therefore therefore I do need an extension of time, and so my submission to the court is an extension of time is appropriate.
But from when, though? You say from the December decision, but the December decision, which you haven't got in the bundle unless I've missed it, was a decision about Article 8 and leave outside the rules.
Yes.
The decision that the rules don't apply to you was given in 2012. That was the subject of appeal and a first-year tribunal decision in 2013. That aspect, the rules don't apply to you, was not the subject of further challenge in JR or on appeal. Justice Holman says it's common ground the rules don't apply. The later tribunal decisions say it's common ground the rules don't apply, and it's all about are the circumstances such that refusal of discretionary leave would be a breach of Article 8. So you need to show us the letter, I think, of 2012 and explain why you should get an extension of time from that.
I understand the concern about that, but I don't accept that the relevant decision is in 2012. And let me explain the submission on that. The reason for that, my lord, is although it's right that the rule was applied to my client in 2012 for the first time and then through the tribunal process, that was capable of appeal under the statutory appeal route to a tribunal whose jurisdiction was limited to the question of whether entry clearance should be granted. That tribunal was not concerned with the consequential quality of leave or type of leave that would be granted thereafter. It didn't have jurisdiction over that issue. The jurisdiction, we don't have the appeal provisions, but I don't think it should be disputed. The jurisdiction of a statutory tribunal in these circumstances.
Yes, but that's not the point. The point is that there are two routes by which your clients could have entered the United Kingdom. One was because they qualified under the rule.
Yes.
And you say the rule is unlawful.
Yes.
And the tribunal can't rule on lawfulness, but it did find that you didn't fall within the rule.
Yes.
Then a separate, quite different issue is whether the circumstances were such that you fell into a situation where refusal of any leave would be a breach of Article 8, and therefore you had to be granted some leave to avoid that. And your focus at the moment is on whether the rules are unlawful, and it does appear that the rules were applied to your client in 2012, and it was confirmed on appeal and never challenged thereafter,
my lord,
that you didn't meet the rule.
I accept that the rule was applied, but it was applied for the purpose of deciding whether to grant entry clearance, not for the purpose of deciding what quality of leave to grant thereafter. And that is exactly the point made by Lord Carnworth in the AA Somalia case.
Sorry, could you just go back? Hold on a second. When you say it's the purpose of deciding entry,
yes.
Looking at the structure of the rules as they then were,
yes.
Was one consequence of the basis on which entry was granted the consequent type of leave that would be given?
Yes, albeit under the FR policy, which I'll come to.
Right, so that once it was Article 8 rather than under the rules,
yes,
then inevitably it was going to be 33 months or whatever it was rather than what you would...
Well, not inevitably, because the Secretary of State has always got a discretion about what form of leave.
It's 2.5 years, but it can be extended.
Exactly.
But it's clear that there are a different set of legal consequences under Article 18. The policy is 2.5 years unless extended. But if you fall into the de facto adoption rules, the starting point is you get the same leave as the adoptive parent.
That's right. That's
and you were told in 2012, 2013 that you didn't qualify.
My lord, the question, I mean, so the question has to be what, I mean, in my submission, the court has to apply this general approach, which I accept in Badness, and which reflects earlier cases like Boddington and so forth, which I have referred to in the skeleton, about the ability to make a collateral challenge, in a way that preserves the ability of an individual to bring their challenge. Now, in relation to the quality of leave question, the leave that follows on from the recognition under the rules or Article 8 or whatever it may turn out to be, in relation to that question, we would not have had a remedy available to us in 2012, because on the one hand, if you bring the matter by the statutory appeal route, the tribunal's jurisdiction doesn't extend to that quality of leave issue.
But that's why you should have brought judicial review to say the rules are wrong.
But then we'd have had to bring judicial review whilst simultaneously pursuing an appeal, bring a judicial review of the refusal of entry clearance in 2012, and we would have been told your claim is either premature or you've got an alternative remedy or both.
No, because you're challenging the rules. You're saying they're applying the rules to me and the rules are unlawful. But I can't go to the tribunal on that because they don't have jurisdiction to quash the rules or declare the rules unlawful.
Can I show...
So and you haven't I mean, it'd be quite helpful to see what the decision of
Can I
2012
show my lord what Lord Culmouth said in AA, because in my submission it's quite important in this issue. My lord, sorry, I'm just going to...
I think we've got to have the 2012
Oh, no, sorry to keep interrupting you. Was your junior about to give you a copy of the 2012 decision?
He is, yes.
and the
Do you think it would be
2017.
Do we have
I'm certainly happy to hand that up. So is this...
We have copies of that as well.
Is it just one decision?
Just one decision.
Right, okay.
Just one appellant.
Oh, so it's one decision for one of the appellants?
Yeah, so I've seen the other 10
will
are
presumably
in
be
the
in
same,
line,
because the latest decisions are all identical, save for the dates and names of the individuals.
Can I hand 3 copies of that up then?
I think we might be asking for a number of documents as we go through.
Right.
We'll do them
Yes.
one at a time.
Yes. Well, can I just deal with a point that I think my Lord Justice
Can we
Lewis
just
raised?
get this first? And
By
then,
all means, yeah.
yes, thank you. Thank you very much. Right, I'm just going to take a moment to look
Thank
at
you
this.
very much.
Right. Yes.
So, my Lord, that's that decision, which I'm not denying is a decision which applies the rules. But the rules are, the submission is that the rules are in effect applied to these individuals again when a decision is made to grant them leave. And to make that good, can I just take you, please, to the way Lord Culmouth approached this issue in AA
Would it be sensible to show us either the application or the decision? Because if they didn't apply into this, or if there wasn't a decision on the rules in 2017...
So, as to the decision in 2017, my Lord, my instruction, we've checked this, there isn't a decision in the bundle because there's no freestanding decision. The decisions constitute the vignettes which appear in the passports. So that all that happens in December is that passport vignette, the passports are stamped.
You mean it's simply 33 months?
Yes, so you have those vignettes at the back of the bundle. They start on page 590. So there's not a reasoned decision about it. We're simply granted leave on those terms.
So it just followed on from the upper tribunal decision of Mrs. Justice McGrath.
I mean, the children are in Afghanistan, so I assume that they have to go along and attend the passport office. The embassy. And
yeah, but the sequence was the UTIAC, the Upper Tribunal Immigration Appeal Chamber, decided in whatever date that refusal would be a breach of Article 8 because it stopped the husband actually being with the children's sister. And following on from that, the only legal event that happened seems to be the vignettes in the passport. Is that correct?
The thing that happens afterwards is the stamping of the passport.
Right, so it's UTIAC, Mrs. Justice McGrath, stamping in the passport with correspondence in between. Is that right?
Yes. There may have been, I'm told there were some pre-action letters in the period in between chasing the delay.
I said UTIAC correspondence and then the stamp in the passport,
Yes.
but nothing amounting to a legal event such as a decision between UTIAC and the stamp in passport.
Well, my Lord, in my submission, the issuing of the grant of leave is a separate legal event, certainly.
That's the stamp in the passport.
Yes.
That's what I've called.
Yes.
Okay,
I'm so
if you want
sorry.
to call
No,
it
so apart from that, I'm so sorry. Correct.
To be clear, what I said was there was UTIAC, Mrs. Justice G. McGrath, and another. There was correspondence.
Yes.
And I said the last legal event was the stamp in the passport.
I'm so sorry.
Now, I'll recall that because you're quite right. I shouldn't use loose language. The grant of leave for 33 months. which was consequent on the UTAC decision, and no other separate legal event that you've identified in terms of a separate application or a separate decision.
Well, there doesn't appear to be any separate exercise of discretion. But as a matter of law, the grant of leave is a separate exercise of authority by the Secretary.
I understand that, but what I'm trying to get at
But
is
there's no separate...
there wasn't a further application saying, please don't forget to look at the rules as well as Article 8.
No.
And there's nothing from the Secretary of State that says, we have looked at the rules, you still don't qualify, but we are giving you 33 months under DLR, under Article 8. All there was UTAC, correspondence, and the grant of...
My Lord, yes. Can I show the court the passage I wanted to show you from AA Somalia? So AA Somalia...
Which bundle?
So that's it'll be volume 1 of the authority.
Thank you.
AA Somalia, as the court will no doubt have picked up, is the decision of the Supreme Court which looked at the interpretation of these rules, and where the court concluded that the rules couldn't be reinterpreted in a way that would benefit, well, the individuals in that case, but it would do the same point in the present case. But Lord Calm made some observations about the way the rules work, which I rely on for my substantive argument. I won't take you to those observations at this stage, but there's a particular observation which is at paragraph 24 on page 53 of the report, 527 of the bundle.
Sorry, could you say that again?
527 of the bundle, 53 of the report, paragraph 24.
Thank you.
And he says as follows: I accept that it appears harsh, to put it no higher, that under the rules AA is treated less favourably than her adoptive siblings, largely because of various tragic consequences. It is, and this is important because this is why the court didn't go further in AA Somalia, it is, however, unnecessary to decide in the context of the present appeal, which is a statutory appeal, where it's being said we should have taken this point, whether or not such treatment could give rise to a claim for unlawful discrimination under Article 14 or otherwise, i.e. the very claim that I'm now bringing. This is because any rights which AA has in that respect would apply equally to her position in this country, regardless of the basis of her admission. Mr. Gill did not suggest otherwise. In exercising, this is a critical point, in exercising any discretion in relation to the grant or extension of DLR, the Secretary of State is obliged to act in conformity with the Convention, including Article 14. It is not necessary to reinterpret the rules to achieve that result. So the exact point that Lord Carnwath is making is that you can't look at this issue in the statutory appeal, which is what this was, precisely because those issues about because you go as far as deciding you get entry clearance or not, which this individual already did have, indeed had got before the case got to the Supreme Court. But then the issue of discrimination would arise afresh when the Secretary of State came to exercise her discretion on the grant of leave. And that fits in my submission precisely with the submission I made to you a moment ago, which is that although I accept that the rule was applied for the purpose of deciding whether to grant clearance back in 2012 and through the statutory appeal process, the appropriate tribunal to look at that issue in relation to the tribunal was not the appropriate place to look at that issue in the context of the legality of the rules, because the discrimination issue would have to be looked at afresh, could be looked at afresh.
I'm not with you at all on this. At the moment, I'm not following.
Yes.
I understand you could argue about 33 months or longer.
Yes.
What you want is to say de facto adopted children get the same leave as their de facto parent.
Yes.
And what you are saying, amongst other things, is that for various reasons, there's been unlawful discrimination here because when they apply the de facto parent rules, they haven't factored in that the immediately preceding requirement can't be met by de facto adoptive children of refugee claimants. But none of that is addressing, with the very greatest respect, the first issue. They were, putting it differently, refused leave to enter
Yes.
because they didn't satisfy the rules. The upper tribunal said that was correct because on the facts you don't satisfy the requirements.
Yes.
So you know the rules don't apply there. If you want to argue that the rules are unlawful because they're irrational, or that it's unlawful to have that requirement in the rules because it disadvantages potential de facto adopted children of refugees, don't you have to do that when you're told, when the grounds for raising that arose, which is 2012, 2013?
Well, no, because the Secretary of State could have chosen perfectly. I mean, the policy, and it's only policy, it's not in the rules. The policy is that you grant leave in line under the family reunion rules if someone succeeds under Rule 352 and not, and you grant a lesser form of leave if you only succeed under Article 8. And the Secretary, and the point is that arises. And but that is not applied to the individual until the form of leave is crystallised by the decisions of December 2017.
It's the grounds of challenge first arose.
But my lord, well,
the grounds of challenge, didn't they first arise when?
Well, my lord, I think one needs to be careful about the word first in that phrase, when the grounds first arose, because in my submission, what that doesn't mean is the first time this rule is ever applied to an individual. It means on every occasion that the rule is applied to the individual with legal consequences. So take for example, the facts of Badmus, for the sake of argument. In Badmus, what happens, the court will know, is that the court decides it's a person-specific, if that's the right phrase, as opposed to an abstract case. The court then, in one case, I think grants. In one case, says, "Well, you're in time on that basis," and the other three cases, there's an extension of time, but it's relatively short, and it's granted. Suppose that you vary the facts of Badmus very slightly. Suppose that an individual is they don't challenge the rule when it's introduced, so that might have been 2014. I don't know the exact Badmus. They're detained in 2018 for a short period. They are not subject. They are subject to the rule at that stage, and they don't bring a challenge. So the grounds of any challenge to the rule would first arise for that individual on that occasion. But they don't. They're released. Perhaps their detention lasts a short period of time. They're detained again, as it may be another 2 years later. The rule is applied to them on a second occasion. For the purposes of that phrase, when the grounds first arose, well, obviously you wouldn't be able to challenge what happened in 2018. But you'd be perfectly able to challenge what happened to you in 2020 by reference to a challenge to the rule.
If it's a continuing state of affairs, and in 2012 you say, "I'd like to have more than £1," and they say, no, the rule is £1. We could pay extra if there were such special circumstances, but the rule is £1.
Yeah.
And then 20 months later you say, "Actually, I'm still unhappy, I would like more than £1, and you've still got the discretion to give me more than £1.
Yes.
Would you really be able to say that if they didn't exercise the discretion to give you more than £1, that was another reapplication of the rules, that it is £1?
Well, I mean, I would say yes on those facts, but in any event, that's a slightly different issue, I think, because that's an issue about whether within a single period of detention you can talk about a continuing, you're subject to the rule every day, which I think is a slightly different issue.
Okay.
So that's why I chose the example of imagine a single period of detention followed by a second period of detention. Or take a different kind of case altogether. Suppose that someone is subject to a rule relating to the grant of social security benefits. They are denied that social security benefit by reference to that rule. For some reason, their claim then ends. They make a fresh claim for benefits 3 years later. The same rule is applied. It's applied to them afresh. It's a new legal event. And therefore, no, they're not on those facts prevented from bringing a challenge, whether it be appeal or judicial review, as it may be, to the application to the rule to them on the second occasion. Suppose in the meantime there's been some critical authority of the Court of Appeal which shows that a claim which wouldn't have succeeded before would now succeed. who knows? But
so, in a sense, your submission is that the rule had a continuing effect
the
on
submission
your clients, and the rule was applied.
The rule was applied
in the context of the December 2017
The submission, yes,
decision.
I think that's right. The submission is that the rule was applied in 2017 for a different purpose, or the consequences of the rule were visited upon my client for a different purpose in 2017, namely to decide what quality of leave they should be granted, as opposed to the decision which was taken in 2012 and was the subject of the statutory appeal, which applied the rule, I accept it applied the rule, but applied the rule for a different purpose, which was to decide upon whether to grant entry clearance. And I repeat the point that not only, so that's the right way to look at it in my submission. There's a new legal event, the grant, which is taken pursuant to a separate discretion about the quality of leave.
I think what one needs, I mean, I do think then you really have to look at the decision of Mrs. Justice Chia McGrath, which is page 31 of the bundle, because she outlines the decision. She goes through the fact that the claim had been disallowed on the grounds, and she then goes on to explain towards the very end what she was doing. And she was saying, not that the decision on the rules, i.e. that you didn't satisfy the rules or that the rules were unlawful, paragraph 19, because of all the facts about the husband being in Afghanistan and not being able to leave because he's looking after the children, we are quite certain that taking the facts as found by the first-tier tribunal judge at 19, the consequence is that the entry officer's decisions engaged Article 8 ECHR and amounted to a disproportionate interference. They are therefore allowed. And she doesn't make a recommendation that entry clearance is granted, but they expect the ECO to deal with the matter expeditiously.
Yes.
So the event that triggered it was a decision by UTAC, not that the rules were unlawful or that they were satisfied, but that keeping the husband in Afghanistan with the children when she was in England gave rise to a breach of Article 8.
Sure.
And then the next thing was that was acted on. You haven't shown us any independent factual consideration of the rules. You seem to be saying that it is inherent in any exercise of discretion that they must revisit the application that's already been refused for entry clearance under the rules.
In my submission, that's correct. So there's a reference in paragraph 20 to the decision of the tribunal not to make a recommendation that entry clearance is granted. That was a power the tribunal then enjoyed under Section 86 of the Nationality, Immigration, Asylum Act 2002. I don't believe it has that power anymore. But that power was limited to a direction: you grant entry clearance or you don't. It didn't encompass you grant entry clearance in such and such a form. So, and I mean, tribunals in practice took different approaches to the exercise of that discretion, but it was rarely a matter of great significance because it's implicit. I mean, where you've got a finding of breach of Article 8, it follows that entry clearance has to be granted unless there's been some significant change of circumstances at any rate. As I understand it, tribunals didn't always make recommendations precisely because you'd have to deal with possible changes in circumstances. So
but the decision can't have been.
Sorry,
go on.
No. Well, if I just finish off the submission, so the decision of the tribunal in principle doesn't even dictate the grant of entry clearance, although in practice it often will. Therefore, the Secretary of State does necessarily have, under the statutory scheme, a separate legal discretion, separate power, to decide whether or not to grant leave, and certainly as to the form of leave.
Mm-hmm.
So that's why I say that's a separate. I appreciate my law doesn't necessarily dispute this, but question this, but that's a separate legal event, separate exercise of discretion. Yeah. And the discretion that is exercised is consequential upon the form of the rules. And that's the point that Lord Carnwath is making in my submission, precisely the point that Lord Carnwath is making in my submission in paragraph 24 of AA Somalia, when he says that you would have to look at any issue of unlawful discrimination in the context of that grant of leave. Now,
the discrimination would only arise
I mean, that's how the Supreme. I mean,
I think they may be dealing with a different thing. But can I just do it another way?
Yeah.
Are you saying, as a matter of intellect, as a matter of physical fact, that the Secretary of State would have had to have applied the rule again, physically focused on the fact they've applied before, they've refused before, there's a recommendation, or not a recommendation, but a need to look at it again. I am physically going through the process. Point 1, the rules do not apply to them. Point 2, should I grant discretionary leave? Are you saying as a physical fact that did happen, or are you saying it should have happened necessarily, notwithstanding the earlier refusal?
So, my lord, the submission is as follows. I certainly don't say it did happen.
Right.
There's no evidence about that, and that would be a matter for...
So no evidence reconsidered the application of the rule
No, there's no
on
evidence that
de
did
facto
happen. That's
adoption.
plainly right. There's just
Right.
evidence about it. It seems, frankly, relatively unlikely. But in my submission, the submission is as follows: that in accordance with the approach of Lord Carnwath in paragraph 24, the section. I mean, one step back slightly and deal with it first principle. So, it's an act of the Secretary of State. It therefore has to be. It's a separate act of the Secretary of State to grant or refuse leave, and as to the quality of leave. It therefore has to be taken in a way that doesn't breach convention rights. That's section 6.1 of the Human Rights Act, as we're all aware. We don't have it in Britain, but I'm sure the court's very familiar with it. And therefore, if the grant of leave in the form of 33 months, I think it's 33 by the way, but nothing. That's 2 years and 9 months. If the grant of leave would result in unlawful discrimination, and that's our point ultimately, we say it does, if the grant of leave in that form would result in unlawful discrimination, because it's consequential upon the form of the rules which have been, then that is a separate, then that engages...
The problem that you've got now is you want to compare de facto adopted children with other people. And you're saying that's what's unlawful. That's at the heart of your claim.
Yes.
But that's not what you're now talking about. What you're really saying is 33 months is unlawful. Why? Because there are different rules for de facto adopted children. And that's one issue. Is it right to have the same leave as the sponsor for de facto adopted children as for other children? And the answer may be yes, you give more to the de facto adopted children because they're coming with their de facto parent. But you don't want to challenge that difference. What you're trying to challenge is something different. The failure to treat your clients as de facto adopted children. And that was done and dusted, wasn't it, in 2012, 2013? That's the unlawful discrimination you're claiming about in this case, is the failure to treat the appellants as de facto adopted children.
My lord, I don't think... I mean, my lord is almost certainly 3 steps ahead of me, but I don't think I am saying... I don't think that's right. The submission is that the consequence of the rule is contrary, taking it at a high level and then we drill down a little. So the rule which we criticise is contrary to the human right, to the European Convention. Now I put my case in various different ways, Article 8, Article 14, and there are 2 aspects of that and so forth. That applying the discriminatory consequence of that rule, namely the form of leave that is... So I'm not... namely the form of leave that is granted to my client, is visited upon them when they get leave in the form that was given in December.
It would be discrimination if, without justification, somebody who was granted discretionary leave outside the rules on Article 8 grounds got 33 months and somebody else got 40 months. That would have to be justified. But you're not complaining about the difference in treatment between 2 people who have discretionary leave outside the rules under Article 8.
No.
What you're complaining about is a rule that says you are put into that box, the discretionary leave outside the rules, rather than the de facto adoption box. And that was done and dusted, wasn't it, in 2012, 2013?
My Lord, with respect, I don't accept that that's the full extent of my complaint. Certainly you could deal with the things we complain of by putting it in the de facto adoption. Or you could deal with it by saying, even if you don't meet, that would involve the kind of amendment to the de facto rule which we say, so for example, remove the 12 months from immediately proceeding to an earlier stage.
Immediately before flight, yes.
Or you could say, right, we'll keep the definition of de facto adoption the same, but we'll create a new category. We won't call it de facto adoption, we'll call it something else, for refugees. There's a hint of this you can see in the 2014, what I call the 2014 paper, where they look at what different drafting techniques to resolve the problem. You could create a new category which would be specific to refugees who don't meet the de facto adoption box, but where there's some new discretion to be exercised, additional discretion to be exercised, or however it may be, so that you could come within the rules. That might, I reserve my positioning depending on the form it took, but that might meet the discrimination at all. That might meet the discrimination or the complaint about under Article 8. So I don't have to say you have. My complaint is not that you have to treat me as a de facto adoption case. My complaint is that the consequences of the rules are that I only get 33 months leave, not leave in line with the sponsor.
And we know that that was going to happen because that's what you were told.
Well, it was, but as I say, we couldn't. I appreciate that, my lord, but as I said, we did know it was going to happen, but there wasn't anything we could do about it for the very reason that I've shown you by reference.
Well, you could have done what you've done now, which is bring a judicial review claim challenging the legality of the rule,
but my lord,
and saying it's wrong. I am the de facto adopted mother, and the 12 months immediately preceding is unlawful. You could have done in 2013, and had to do in 2013, because the tribunals couldn't, under its jurisdiction, quash or declare unlawful the rule.
It couldn't quash. I think it could declare unlawful, but the point about AA Somalia, because it would be entitled to say, but the point about AA Somalia, it says it would never go that far, because the only question on the statutory appeal is whether to grant leave. So once you've concluded that on the facts there's a breach of Article 8, for example, as happened in both AA Somalia and my client's own cases, the tribunal will say, well, there we've discharged our function, the refusal of entry clearance is unlawful, Secretary of State go away and deal with that.
But if there are people who are discretionary under Article 8, where's the discrimination? All people who are discretionary under Article 8 get 2.5 years as a starting point unless there are specific reasons.
But the discrimination of which I complain is the discrimination between, well, I put it in various different ways, but let's focus on one for the sake of argument for now. So the discrimination I focus on under my Article 14 argument is the discrimination between refugees who are incapable of meeting the current 12-month rule and other de facto adoption applicants. Because the latter, they don't face the insuperable obstacle to meeting the rule, we're getting a little bit into the merits, but that it's impossible to meet the rule because you've necessarily fled the country. And therefore they would be able to be granted leave in line with their sponsor, or at any rate not outside the rules, in circumstances which are just not available to my client. So that's one of the versions of the Article 14 argument. And that consequence, in terms of grant of leave, as I say, is visited on my clients in December 2017. Well, I know that this point isn't going to completely satisfy you, but I feel I must mention that certainly as I understand it, the respondent's case is that the decision we should have challenged is that of
December 17.
December 17.
Yes.
You have that in the detailed grounds.
Yes.
So
no, that is the point. Thank you.
Anyway, that's a submission. Applying Badmus or applying Boddington, which I won't go to, because if there is a legal event or a legal discretion being exercised, which turns upon the rule, which the rule has consequences in relation to, then it's legitimate to challenge the rule at that stage. And the fact that the rule was applied to one in a different circumstance at an earlier stage doesn't bar that challenge. Otherwise one would be, I mean, again, take an immigration detention case where someone is detained, they say that the Secretary of State's policy for detention is unlawful, they're only detained for 2 weeks, they never get around to challenging. 3 years later, they're detained for a number of years. It can't possibly be right that their failure to challenge the policy at the earlier stage bars a challenge at the later stage. And a fortiori, where other people will, if I may say so, be in a position to do so. Because one of the oddities about this case, and one of the submissions I would make to you in any event, is that there is a significant whatever the position on delay, and whether it's 2012 or 2017, there's an obvious and significant public interest.
It's a separate question.
Well, I understand that, but I just want to flag it at least.
Yes.
I mean, that's a submission which I hope the court will be alive to the fact I wasn't expecting to deal with.
No, thank you.
Do my best to deal with it. On why it's 2017 and not 2012. The submission which I go on to make is that in any event, and I think I make it whether it's 2012 or 2017, is that the court should grant an extension of time. Now, obviously, I'm going to have a higher hurdle on that if it's 2012, not 2017, but I do propose to make those submissions in any event. I mean, the way I've ordered the submissions is principally by reference to 2017.
Yes.
So I make that submission, but...
Thank you.
When you refuse the application by the High Court, you have to demonstrate that the High Court judge was wrong, really. Not for us exercising fresh discretion. The High Court judge did consider it, and she refused it, as I recollect.
She did.
This is an appeal. We haven't yet got to, if we do allow that, what do you do next?
She accepted that the claimants had acted in good faith.
Yes.
Decided that good faith does not provide a reason for delay.
No.
And really rests her decision on her interpretation of the letters.
Yes.
And your submission, I suppose, is that if she's accepted the good faith of the solicitors, then it was their interpretation of the letters which led to or which was one of the reasons for the delay.
Yes. Yes, I mean, that certainly is...
And I think you were going to take us to the letters.
Yes, I was, and my lord, that was the next...
Sorry, I don't want to take you completely out.
No.
I think we've blown up the order of your submissions. But do you want to go back to the order of
perhaps
your
submissions? Perhaps I should.
Okay.
And certainly the next... I mean, to give you the headline points, I say there are a number of reasons why an extension should be granted. Now, I formulated these points in relation to 2017. Some of them are going to be more important, some are going to be less important in relation to 2012. But if I give you the headline points and then go to develop them slightly. So first of all, my lord, it is critical, and this is the point I'll go to next, to look at what happened in the winter of 2018, effectively, in relation to the way the Secretary of State responded to this application. Secondly, and I can see this point becomes a slightly different point if one is looking at it in relation to 2012, the overall history of this case is, in my submission, very significant. Thirdly, it's not said, as I understand it, that there is any specific prejudice to the respondent by reason of any delay. I mean, they no doubt point to general considerations of good administration, and I don't diminish those completely, but it's not said there's a specific prejudice, and for a reason I'll come to, I suggest there wouldn't be. Fourthly, if we're right about the substantive matters, and obviously I haven't developed my submissions on that as yet, there are very significant consequences for these individual appellants. And lastly, and in my submission this is a really powerful point, even if one is looking from the perspective of 2012, there's the public interest in having this issue determined, because there is a significant legal issue here and it's going to, if the court doesn't determine, it's going to hang around and need to be decided in other cases. So developing those points, hopefully reasonably efficiently. Can we look at then at the letters? They're in the reverse chronological order in the bundle. So we start briefly with the letter before claim that's written on 15th of February 2018. That begins at page 584 of the bundle. I wasn't going to go through the letter in detail, save to note the point that it's a letter before action in relation to the December grants, formulated as such. And it's completely clear, and you can see that on page 587, that the matters complained of include the illegality in the rules, which then comes forward potentially before this court, subject to the debate we're having now. So that's a Timaeus letter before claim. It's responded to on the 1st of March. And in my submission, this is a very important letter. That's page 582. Going backwards. That's obviously a very short letter. But the response is, and the substance of page 583, with apologies for the delay, I can confirm that this office is seeking guidance from the relevant UK VI department on your claim. So we're looking into it effectively. And in particular, the endorsement on the proposed applicant's visa of 33 months limited leave. As soon as we have the required information, we will be in touch with your client as appropriate. And then critically in my submission, I hope this information addresses the points raised in your pre-action protocol. And obviously it doesn't do so in the substantively, so that means, as it for the time being, and negates the need for you to pursue the matter to judicial review. So the completely clear sense of that letter, or the way it must have been received by those instructing me, so I wasn't involved at the time, was, please don't bring your claim for judicial review. We're looking into it, and we'll come back to you substantively.
Well, it's the second part. Are you saying the entry clearance manager was saying, we are considering whether or not to review the rules and amend them?
No, I don't imagine they were going that far, but they were considering whether what form of leave should be granted to my clients. I mean, obviously, if at that stage the Secretary of State or the entry clearance officer responded and said, we're not doing anything about the rules, but we're going to grant you leave in line with your sponsor, then I don't imagine we would have needed.
I just want to get the facts clear. I understand the point that you're saying, wait, please don't go now.
Yes.
I understand that, and you're saying wait is relevant to discretion.
I do.
I've seen Mr. Chung's statement this morning that says he believed that a fresh decision would be taken.
Indeed.
But he doesn't deal with the rules in that statement. And I'm asking you, and from what you've just said, no reader of this would have read it, a letter from the entrance clearance officer in Islamabad, as being an indication that they were going to review as requested the rules, whether or not they were going to take a different decision on 33 months as opposed to some other period.
Well, I don't. Just so I'm completely clear in the submission I'm making, or what I'm accepting, I'm not. I mean, this is a letter by the entry clearance officer who would not have had the power to change the rules
and
in any event.
Nobody would have assumed that he was undertaking or promising to review the rules.
No, but equally,
so let me find out and get back to you, and don't sue at the moment, rather than don't sue because we're in the process of reviewing the rules. That's what it is it?
It's not a representation that they are actively reviewing the rules. It's just a general representation that we're looking into the matters you've raised in your letter, which include the question of the rules and also the consequences of those rules.
So you're looking into the claim and wait until we come back to you before you sue.
That's the sense of it, my submission. And anyone in my respectful submission, anyone receiving that letter would say, okay, I'm going to hold fire. I'm not going to bring my claim now. Now, obviously, that's going to matter less if I've got to establish an extension of time in relation to 2012 rather than 2017, but certainly in relation to 2017.
Because what your clients were concerned about was yes, okay, at a high level the rules, but actually it was the endorsement.
Yes, absolutely. I mean, the logic of the argument, of course it's true that the logic of the case that they brought, and indeed that I put before the court today, is that the reason it was unlawful to give them 33 months is because of the problem with the rules.
Yes.
And not anything else. And certainly we're not developing any other argument to this But for them individually, what they wanted was, and one maybe if they'd not changed the rules and not change the rules but change the decision for these individuals, they could have contemplated a claim which would have been, inverted commas, academic, but it seems you probably wouldn't have done it at that stage.
And when the judge said that she accepted that the claimants acted in good faith,
yes,
I take that as an acceptance as to the explanation as to why what happened happened. In other words, that they did believe that there was going to be reconsideration.
Yes. At least, and possibly on whatever basis we don't know, but at least in the individual case.
Yes.
But necessarily, and the only point that's raised is a problem with the rules, effectively, that we bring before the court. So for those reasons, we say that's a very strong reason. Well, let me just complete the picture there. So then that's responded to. So then nothing. So notwithstanding the indication of coming back as reasonably quickly, that's responded. That nothing then happens. The challenge period, the original challenge period, does expire. I completely accept 12th of March, and then on 579.
I suppose you can say that the judge focuses on the phrase "seeking guidance,"
yes,
but doesn't actually address the final paragraph.
Absolutely.
Saying, don't issue judicial.
I do, my lord, I do. And one has to, if I may say so, one has to look at this, going back briefly to 583, one has to look at in the context of lawyers who are acting in potential proceedings for judicial review, fully alive to points that are going to be taken about, well, it's premature because we're still thinking about it and all the rest of it, the difficulties they're going to face with the legal aid agency if they try and jump the gun, and all the rest of it. And in those circumstances, yes, it says we're seeking guidance, but I mean, I don't understand that. I suggest that doesn't get read as anything more than that we're going up the chain about the matters you've raised in your letter. It's not a statement, or couldn't, in the context of the letter that precedes it, be read as a statement simply that we're going to double check we apply the rules correctly. It goes beyond that.
It's just a statement saying, I've got to go up the chain.
Yeah.
Please don't do anything till I come back down to you. That's all it is. It's not that we're going to review the rules, we're going to take a decision. Yeah. I can't answer your letter. I need to get guidance. Yes. Please don't do anything whilst we are doing that. That's what he says.
Yes, and it's not. I mean, I accept it's not a representation as to a fresh decision, perhaps, but it is a representation. We're going to look into the matters raised in your letter, and we don't want you to bring a claim for judicial review ahead of that.
And you might say that then, when did you say time expired?
12th of March.
So it's a week probably after this letter, or some 10 days after this letter is received.
11, 12 days, yeah.
And there's no indication in the letter, but don't forget the time.
Yes, exactly.
And
exactly. That's quite important because I mean the court will have probably seen, certainly my Lord Justice Lewis will have seen plenty of these letters where defendants do write and say, of course, we're not. Don't worry, that's all very well. But by the way, you've got a 3-month deadline. I mean, it's not saying anything of that kind.
The strict response by a lawyer for the claimants would have been, the protocol makes it quite clear that the time limits can't be extended by agreement or by pre-action protocols. But the strict lawyer would also say, but it is a factor relevant to an extension.
Absolutely, I'm relying on it.
Not a new decision that starts. No, I'm relying on an extension for a reasonable time.
I hope I've made clear that the submission I'm developing to the court is that it's appropriate to extend time. And I do, with respect, say that this is a very powerful factor in relation to that matter.
The next question is extension of time to when?
Well, so, yeah, I've done that. So can I just complete the picture? So then you get the Duncan Lewis chasing on the 23rd of April. That's 579. I don't think we need to look at the detail of it. It's just making it. And then the further response to that is the 26th of April, which is understood, and I'm not making the argument correct, but is understood by Mr. Cheng as a fresh decision, capable of challenge. And that's pages 577 and 578.
But it's not, you accept a fresh decision, so it extends the time on your analysis up to the 26th. They've got to have time to proceed thereafter, but they don't. They wait for 3 months.
Well, I appreciate that, but my lord, first of all, the reason for the 3 months is then the one that we've seen, which the judge accepted in right or wrong, but in good faith. We thought we could challenge this, treat this as a new decision, and we thought we had 3 months. So that's the reason.
The question is, do you regard it as a valid reason for extending time that there has been a good faith error on the part of the lawyer?
So what my submission to the court is not that in all cases where there's a good faith mistake of that kind, you should extend time as though the thing that the person mistakenly believed was actually correct. I mean, I don't put my case in that.
Well, for example, they just thought it was 6 months.
Yeah, exactly. I mean, obviously not every mistake.
Yes.
It doesn't, I completely accept it. The fact that you make a mistake doesn't mean that you shouldn't ever be visited with the consequences of the mistake. I take that.
So good faith error on the part of the lawyers as to the status of the letter.
Yeah, but it is a relevant factor.
But even if 26th of April were a fresh decision, it doesn't give you another 3 months.
Yeah.
My lord, it does if it's a fresh decision.
No, it doesn't.
Subject to I was going to say.
And in any event, no later than 3 months.
I accept that, my lord. But it's not. This is a slightly hypothetical debate because it's not. I'm not submitting this as a fresh decision. But suppose, for the sake of argument, if we to test my lord's point,
It is, because if Mr. Cheng's evidence was, well, I thought I had another 3 months now, then he had no rational basis for thinking that.
Well, look, if this was I mean, I don't want to take up too much time on this hypothetical point, but if this was a fresh decision, and it isn't, so, but if this was a fresh decision, it would start time afresh under the CPR, 3 months and promptly, I accept.
No. 3 months and in any event, no later than.
It must be both, it must satisfy both. So,
No, it must be prompt, but if it's not, if there's arguments about promptness,
yes.
or you think it might be prompt, or not prompt, it's got to be. There can be no arguments after 3 months.
Yeah, I'm not seeking. I appreciate that you have the 2 requirements, and I know the formulation of the CPR. But my lord, there are cases obviously where 3 months will obviously require promptness over and above. Where promptness will obviously require action more quickly than 3 months, and planning cases, they're no longer governed by the rule, but are an obvious example, or other cases where you've got a third-party interest affected. In my submission, this is not the kind of case where action more than 3 months, more quickly than 3 months would have been required. I'm going to come on to the point that this whole process, looked at as a whole, has gone on for years and years. You get your entry clearance application in 2012. You only get in. You win in the upper tribunal in middle of 2017. You get 6 months before the Secretary of State takes action upon that. So the tribunal decision is June 2017, and entry clearance not granted until December 2017. In my submission, this is not a case where, again, this is a slightly hypothetical question, for the present purpose of my Lord Justice Mail's point, but it's not a context in which, provided you acted within the 3 months, a powerful point could have been made against us on promptness.
But he doesn't explain why he didn't act within 3 months.
He did act within the 3 months.
Yeah, well, yes, why he waited until the 5th of July.
He doesn't explain that, no. But then no point had been taken on promptness as a freestanding, as I understand it, in relation to...
No, but your obligation is to provide an explanation for each and every period of alleged delay.
Well, look, the bottom line is, I mean, and this brings me on to the next sequence, into the next bit of the sequence of my submission, is that in my submission, what this correspondence does is provide a very powerful case for an extension of time over and beyond the 3 months. Respectfully say, a very powerful case. I take the point that there's still something of a lacuna, because it might get me into, let's say, May, but it might be said it doesn't get you into when the claim was actually brought in July.
25th of July, the end.
Yeah. July. But, my lord, that's why I want to develop some other submissions on why an extension of time is appropriate, because the court has a discretion, and my point is that on any view, this is a case where a pretty significant extension of time would have been appropriate. Now, whether the court would extend time as far as July. If I stop there, well, I can see I might be in some difficulties, but that's why I want to develop the other points.
Yes.
Well, the second point that I make is the one I've just foreshadowed, and I can take relatively quickly, which is the general shape of, if I put it like that, the general shape of the history of this case. And I just made the point really, but this is a process which, from my client's perspective, commences in 2012. It does take 5 years, so their application is the summer. I don't think we have an exact date, but the application for entry commences the summer of 2012. And they battled through the tribunal system for 5 years, including appeals to court of appeal, and so on, for 5 years to get to the point where they succeed in establishing an entitlement to come. It then takes the Secretary of State 6 months to act on that recommendation, notwithstanding the hope expressed by the upper tribunal. Please don't turn it up, but it's paragraph 20 of their decision, on page 37 of the supplementary bundle, that the entry clearance would act expeditiously, precisely because of the very serious family circumstances that have been identified. But it still takes them 6 months to do something about it. And in those circumstances, in my submission, it's a relevant factor that the process has taken that long in considering whether the consequences of a delay in bringing the claim to judicial review should be visited upon my clients so that they're barred from bringing this issue, which is of considerable importance. So that's the second submission. The third submission, which I'll take very shortly because I don't, that's a matter for Miss Broadfoot, she says it's wrong, is that as far as I can see, there is not said to be, and could not be, any specific prejudice to the respondent.
I'd understood the law to be that when you're dealing with good reason, the absence of prejudice wouldn't be a good reason for extending time, but if there was prejudice, that might well make you pause.
Maybe it's a negative factor, but it
doesn't justify an extension, but it might be a reason why you wouldn't grant it.
Yeah, well, it goes into the mix. I mean, I take the point. Fourth point, my Lord, and to some extent this will engage the merits of the claim, of the substantive issues which you haven't heard. Fourth point, and obviously it's well established that the merits of the claim for judicial review are a relevant factor. We say, and I haven't developed these arguments, this is a meritorious case, but in any event, in addition to merits as such, if we're right about all this is a very, very significant matter for my clients. Because if we're right about this claim, or the arguments pursued in the appeal, then my client should have been granted leave in line with the consequences that they would then be on a path to settlement. Whereas, if they're prevented, notwithstanding that right, that correctness or putative correctness, they're prevented from pursuing the claim, then the consequences for them are very severe, and they could be as serious as that they have to return to Afghanistan to restart their lives, or short of that at any rate, that they live in considerable uncertainty, legal limbo, for many years of repeat applications for extensions of time until at some point in the frankly unpredictable future their position is regularised in some sort of way. And that is I do respectfully say that is an incredibly significant matter, especially for children who've been through the life experiences which the court...
So 8 of the 11 are now adults and only 3 are still children.
Well, they are, but that itself goes back to the point that... But first of all, yes, but that in a way, I mean, that cuts both ways because it makes the position.
But it's just the word children. It's accuracy.
I'm so sorry. Yes, it's right that they are. Many of them are. Yeah. That's perfectly right. But
8 of the 11 are now adults and 3 are children. One is 13, I think. One is 16, and one is 17.
Yes, but the logic of our case is, if we're correct, is that they should have been granted.
Yeah, I was only commenting on the word children and the suggestion.
Sorry, no, fair enough. I mean,
that these are children and so on. 3 of them are children. 8 of them are adults.
Yeah, fair enough. Quite. My lord is quite right to bring that. The former children and current children. Yeah. But anyway, the substantive point is the same point. It's a matter of the most consequential kind for them. And if we're right now, if we're right that they have suffered a breach of their human rights, that's a very powerful matter in the exercise of discretion. The last point, my Lord, then is the wider public interest. Because the issue raised by the claim or appeal, a little unsure which I should call it in a case like this, but call it the appeal. The issue in the appeal is a matter of general importance. And it's a matter of general importance, which, see the evidence, for example, of the Joint Council of Welfare of Immigrants, has had consequences and will undoubtedly continue to have consequences for a wide variety of persons. So there is a strong public interest in the court resolving it, having had a time set aside to hear argument on it. I'm conscious we're eating into time, but having had time set aside to hear argument on it, having had the in my submission, very helpful intervention of JCWI, and in circumstances where if the point is not determined here, it may well, I would go so far as to say, will have to be determined in some other case. And in that regard, my Lord, in my submission, going back to the point about prejudice in the Secretary of State, it's positively in the Secretary of State's interest that the matter should be determined sooner rather than later. It's plainly in the interest of those other persons affected. Because if it's not determined now, then it will arise in some other case. The arguments, in the smaller picture, the arguments will have to be got up again, presumably. And on the bigger picture, none of us know where we stand legally for an extended period of time. And some other appellant will have to battle their way through the tribunal system, or bring their...
No, it'll be JR. They can't, in the tribunal rule, it will be JR.
Well, however they have to do it. I mean, it comes back to the question, but one way or another, they're going to have to, or they have to bring their claim at the same time. I think the logic of the court's concerns over the 2012 decision, you have to bring your claim right at the start. But however you have to do it, I mean, one can anticipate that being met with arguments by the Secretary of State about why the claim shouldn't be allowed at that stage, because it's academic, or it doesn't arise on the facts, or it's premature, or one can well imagine the sorts of arguments. And the point doesn't get determined, or may not get determined. So in my submission, there is a strong public interest in granting the extension of time. That's a positive reason for the grant, over and above those other ones that I've outlined. Now, just coming back to where I started, in my submission, there is clearly a case for an extension of time beyond the 12th of March, for the reasons I started with in relation to the letter. The difficulty which my Lord Justice Lewis points out is, well, that doesn't necessarily get me all the way to July. But there is a reason given for the failure to bring the claim more quickly. That the belief of the solicitor was they're capable of bringing a new challenge. As I say, there are very powerful wider factors at play, both for my clients individually, that was my fourth set of submissions, and in terms of the general public interest. And so those are the submissions on delay.
Can I just ask you about the merits?
Yes.
I'm really concerned about, you say the merits, and you're assuming that the merits of your clients, and I'm talking about legal merits, not human merits. Sure. I fully understand what they've gone through in Afghanistan. Well, I can't ever fully understand. I know they've gone through a bad situation in Afghanistan. I know they're with their sister and her husband now. I'm not talking about the human consequences, which are shocking. Legally, the only facts, because we haven't got evidence, the only facts we've got are the first-year tribunal findings of fact on the rules, and those haven't been upset or overturned on any subsequent finding. Indeed, the UTX said they were proceeding on that basis. Yeah. And what they say there, if you go back to the rule, there are a number of problems. One is the 12 months immediately preceding and the application for entry clearance, and you object to that for the reasons, as you say, people have to flee. Yeah. The second requirement under the rules is a period of 18 months living in the country. Yes. And thirdly, that during that 18-month period, there's been a genuine transfer of parental responsibility. And what the tribunal says at first instance is, firstly, you couldn't establish the 18 months because the sister had been in Germany for a while and she went back in probably November and then got the legal guardianship order in December 2010. but had left in March 2012, so there wasn't 18 months. But secondly, and more substantively, the findings of fact by the tribunal appear to be saying, when you read them, that whilst they accepted there was family life, over and above normal family life, between the sister and her brothers and sisters, it found it stopped short of being in loco parentis and stopped short of being de facto adoptive parents. So, although you might say the rule, insofar as it deals with the immediately preceding the application for entry clearance, is questionable, would it have altered the conclusion in this case that even if that element of the rule went, nonetheless, your client's sister wouldn't have been able to have established that there had been a de facto adoption, which is what this is looking at, because she hadn't lived there for 18 months, during which period genuine parental responsibility had transferred.
Well, as to the point about the 18 months per se, as opposed to the transfer, my lord, I think my learned friend's position is it's not clear that the 18 months has been satisfied. So that's not an issue on which I think there was not sure that there was a clear determination on that. But in any case, first of all, if the court concludes that the application of the 12-month rule, because it was accepted by those acting at the time that the 12-month rule was made the rules a non-starter, effectively. Not sure that it was accepted on the other points. And if the court concludes that the application of the 12-month rule is itself unlawful, then first of all, in my submission, that has very important consequences for the way you would exercise discretion in relation to these individual applications. Whether or not we could go so far as to say that the it would automatically succeed in
Well, it's to be fair to you, supplementary bundle, page 5 and 6.
Yes.
That I got this from, because you haven't put in any facts. There may have been statements in the High Court,
yes,
but we haven't seen any facts. And there's paragraph 19, which, having set out the facts and having found the sister credible, says the sponsor is said to have taken responsibility for her siblings in November 2012, and she fled in March 2012. And it says there is significantly less than 18 months between the sponsor taking responsibility for her siblings and leaving the country. That's the first point. But then at 17, and in particular at 23, having reviewed all the evidence and so on at the time, at 23, I find that the sponsor and her husband are effectively the sole legal guardians of the appellants, and the relationship is likely to go beyond what is normal. But I fail to find sufficient evidence, and he's recited it earlier on, that the relationship had reached a stage at which the relationship was equivalent to a de facto adoption. So all we've got on the facts, although you say the merits of your client's claims are strong, it may or may not be strong on the 12 months immediately preceding, but it's the 18 months and the transfer of parental responsibility that I'm troubled by.
Can I just turn my back for a moment? I just want to ask my junior to look at something while I... I understood that the point was taken about the 18 months per se. I hadn't understood a point to be taken by the other side on transfer of responsibility beyond that. It's certainly right that the factual finding in relation to that was put in issue as at a later stage. And you can see that forgive me.
We're not deciding the merits, whether he can establish on the material before us. He's saying that it's relevant to the exercise of discretion, but there are strong merits, and the answer is not on the material yet shown.
I'm sorry, I don't have the reference to hand, but there's a passage where certainly some criticism was made of that finding on the basis effectively that...
Mr. Justice Holman says when he granted leave in his reasons, and that's at page 12 that he conflates certain issues, and paragraph 17 and 23 aren't clear. But when you read that, unless you want to make submissions to the contrary, it appears to be saying that what he's done there is equated the finding that there was no de facto adoption, and he's fed that into Article 8 in an inconsistent way, because even if you're not a de facto adopted child, these children had nowhere else to go except their sister. But that's a different issue. And then the last, most recent decision is...
There's then Judge Monson.
Yes, and also page 34, paragraph 12, the last sentence, in the last judicial decision, which was the upper tribunal. I'm sure you read all of these since you put them in. Both sides were content that we should consider the evidential findings made by First Tribunal Judge Seelhoff. Now, we aren't deciding the merit at the moment.
No.
All I'm raising is this query. Well, you said that it was relevant to the exercise of the public, relevant to the exercise of discretion, that your clients had strong merits.
Yeah.
And all I'm saying is that on the evidence before us, that may or may not be true in relation to one element of the rules, but are you able to submit that on the evidence before us, we could be satisfied that there were strong merits?
My submission is, first of all, that there's a strong merit. The arguments which we've developed in the claim, which is the argument about why the 12-month rule in particular is problematic, those arguments also go, albeit I accept in a less direct way, to the requirement for 18 months, because for much the same reasons, refugees may well find it difficult to satisfy the 18-month rule. If you think about it...
There's 18 months and it's got to be preceding the application for entry clearance, and logically the same criticism would apply to that.
It does.
As applies to the 12 months.
Correct.
But if you get to the last part, the reason why you have 18 months of living in the country where the child is, and the reason why you have 12 months where the child is living, as a factor that you take into account when you're assessing, so that genuine parental responsibility has been transferred. Because this is about whether a de facto adoption has taken place. So it's the 18 months as a period when transfer of responsibility occurs, not the immediately before the application.
In my submission, a finding by this court that even the 12-month rule is an unlawful rule for the reasons we've developed would be a very significant matter, not just in the general public interest, though that's certainly right.
No, this is about the merits of your clients.
But also for my clients, because the Secretary of State would then have to look at the exercise of discretion afresh on a different basis, which is on the basis that the 12-month requirement, which was imposed upon my clients, was not a lawful requirement.
Yeah.
And
but you in this analysis have meant the 18-month requirement to the transfer of parental responsibility. I'm not sure how. And this is your submission that
and then the difficulty, my lord, and it's the same difficulty that a refugee faces. If the refugee is required to leave is forced, as it were, to leave the country early because they're fleeing persecution, then that's going to impact upon their ability to satisfy the 18-month rule, whether it be the 18-month rule in the strict sense of 18 months or the transfer of responsibility rule.
Yeah.
Because, for the very reason my lord just pointed out,
I understand the difficulty in achieving a de facto adoption, because if you have to flee the country, you're not there. But that's a different question from satisfying the rules in the abstract. The question is whether or not a de facto adoption had taken place, not whether a de facto adoption was prevented from taking place because somebody had to flee. And here...
Yes, but that goes... Sorry, forgive me. My lord.
We're not giving people under these rules leave to enter because they would have become de facto adoptees had the situation not arisen when the person had to flee. This rule, 309A, is looking back. Has a de facto adoption taken place? That's what it says at the beginning. And you're looking back to, has there been a period of time when the person was there and during which responsibility transferred? Was there a period of 12 months living?
Sure.
The period of time by which you establish it is, as you say, an issue.
I understand that, but my lord, our submission, I mean our overarching submission in the claim, looking at the substance, is that the rule as it stood was unlawful and discriminatory against refugees. So if we establish that, and that the rule should have been different, then we establish that it was discriminatory to deny us the benefit of the rule, and that will
No,
go to...
You establish that you can't be denied the benefit of a rule, but it doesn't say, I mean, on that analysis, if you declare the whole rule unlawful, because you can't sever the words immediately preceding, you've got no rule that entitles adopted children to come here at all.
Yes, but the Secretary of State would then have to consider how to exercise discretion in my client's case on the basis that they were operating in an unlawful rule.
No, there'd be no rule.
No, because we're not. This court can't achieve a result. That was it. That was what was thought to be done in A. Somali of reinterpreting the rule. I can't say we did in fact satisfy the rule because it should have been interpreted differently, under Section 3 of the Human Rights Act. I say that the rule that did exist was an unlawful rule, and instead we didn't win under the rule. We won under Article 8. That's the basis on which we were granted entry clearance. Secretary of State then has a discretion how to consider what form of leave to grant. And the critical element, which I say should have informed, if we're right, is that the rule was a discriminatory rule. So the discretion would have to be exercised. We quash that decision, and the discretion would fall to be exercised.
You only challenged the 12-month immediately preceding part.
Yes.
You haven't suggested the rest of it is unlawful. And on that basis, the bits that you haven't challenged, on the evidence set out by the first-year tribunal, you don't meet. Now, the only alternative to say, well, you can't just deal with one part of the rule.
Yeah, well,
the whole rule goes.
Yes.
Then there's no rule entitling de facto adopted children to come in.
I'm probably being dense, and as I said before, my Lord is almost certainly many steps ahead of me. But that is what I say. There wouldn't be a rule, but in the context of this case, there not being a rule or not being a rule that was capable of being applied is not a problem for me, because there will be cases where Burnip is an example.
If you're saying, well, there's no rule, the Secretary of State will have to exercise her discretion, which I think is what you are saying, then why should she exercise her discretion on a factual basis different from the findings of the first-tier tribunal, which are that the loco parentis was not satisfied?
She should exercise her discretion on the basis that my clients were caught and prevented from obtaining leave to remain at an earlier stage and a different quality of leave to remain on the basis of a rule which the court, on this hypothesis, would have found to be unlawful, and therefore they were the subject of discrimination.
Right. Now, what do your clients say? That if they accept the findings of the first-tier tribunal, they come along to the Secretary of State and they say, our sister is not in loco parentis, but we want you to exercise discretion because the rule you've got is unlawful on the basis that she was in loco parentis. I mean, that's an incoherent position.
Well, can I just take a moment? Well, my Lord, I think I've made the submission.
All right, fair enough.
Your submission is that the decision would be quashed because it would be, on your case, based on the application of an unlawful rule.
Yeah, that's the submission.
And would have to be remade.
That's the submission. And it would have to be remade on the basis that the rule which was applied to them was an unlawful rule,
yes.
and that would.
And it's not.
And was it? I'm so sorry. And was unlawful because it was discriminatory.
Yes.
That's the submission. I mean,
and it's not your role to remake the law.
Correct. Absolutely right. And
it's the Secretary of State's role to respond to a finding that the rule is discriminatory.
That's right. And the problems which it's right that we focus on the 12-month rule, but the problems which apply to the 12-month rule apply to the other issues which the court has alighted upon. Because just as you've got a difficulty in meeting the 12-month rule, for the reasons we set out in the skeleton, so too you may have a difficulty in satisfying the 18-month rule, or indeed the requirement of a transfer of responsibility, for the same reason. If you think about the position of a person who's seeking entry clearance other than in the context of refugees, and they're, 15 months in, their solution is, well, we wait 3 months and then we make the application. that's an option which for a refugee is a non-starter.
Well, you haven't put that in, and you haven't challenged whether it's done by months or not by months. There's got to be. This is for people who are de facto adoptees, and the last requirement of the rule is that there be a genuine and substantial transfer of parental responsibility. And the tribunal here said there wasn't that.
One would have to look at it on the general facts, including, by the way, that even in the period before, because remember, my client comes to the United Kingdom in March 2012. The application of entry clearance, there's then a delay because she's applying for asylum. The application for entry clearance is made not in March, but in the summer of 2012.
It's 26th of June 2012.
26th of June, I'm grateful. By which time the children have continued to live with the husband, who's taken over in practice. There's no formal adoption order, but he's taken over in practice. Okay? So they've continued to be part of the family unit by now for a period of more than 18 months.
The problem you've got with that is that may add another 3 months, and you may be able to get from November 2010 to the end of June 2012, and you may get through the 18 months.
Yes.
But the first tier tribunals, I'm sure you remember, went through the evidence of the 3 months afterwards and didn't find that there was in loco parentis. She was the sister, she was the legal guardian, she was looking after her siblings and sending emails to her husband about how they should be looked after in major decisions.
Well, sure, but
he simply finds as a fact that there wasn't in loco parentis, and there's no perversity appeal against that, and we've got no other evidence. And this isn't for us finding the facts. No, this is just your submission that the merits are so strong that an extension of time should be granted. I'm saying, well, at the moment, is that perhaps putting it too highly?
Well, Lord, I think we're dealing with the extension of time point at the moment. I don't want to.
We are. It's the strength of the merits.
Sure.
For the purposes
well,
of
we say.
considering.
I mean, the submission is. We say that's an important factor, but what I was really saying about that is the significance of the consequence.
Yes.
And that's the submission. I mean, I don't want to go around that. So, my lords, I'm taking it that you. Oh, do you want to hear me on the 1 day extension? I'm
afraid that's all right.
No, I don't think so.
No, I'm grateful. So those are my submissions on delay.
Thank you very much. Yes, Ms. Broadfoot.
Thank you, my lord. There is a chronology at page 73 of the bundle, which might be helpful when we're looking around in relation to dates.
Sorry, could you say that page number again, please?
73, my lord.
Thank you.
It was attached to detailed grounds, and it may be useful to keep a finger in it. The question is obviously, when did the grounds first arise? And it seems to now be conceded that, or it's certainly the position that the relevant date is the issuing of the vignettes on the 12th of December 2017. Having been alerted to Badmus and Delve yesterday and read them, it seems to us that there are a range of possible dates from which the grounds could be said to have first arisen. The first one is in fact the 7th of November 2012, which is when the claimants were refused entry clearance. Now you've obviously heard my learned friend Mr. Green's submissions about why it shouldn't be taken from that point. But what needs to be remembered is that this was a single application. So the application was made a date before 2012. It was obvious on the face of the rule that they couldn't meet the 12 months immediately preceding, even if they were able to meet other parts.
Is this a new point that you're taking?
It's a new point arising out of having read those cases.
So
Delve
in your submissions, you were contending for the 12th of December as being the relevant decision which was being challenged.
That's absolutely right. And if the court decides to hold me to that as a matter of fairness, obviously I can't object to it. But because the court sent us, alerted us to those cases yesterday, when you look at both bad news, the paragraphs that Moylan friend pointed you to, and delve at paragraphs 121 to 124.
Sorry, you want to take us to that?
Yes, please.
Were you finished with the chronology, or was there any other date you wanted to draw out from the chronology before we put that away?
Yes. So the other date on the chronology was in fact the 29th of June 2017, which was the date on which the claimant's appeal was finally allowed on the basis of Article 8. And so at that point, of course, a decision was always going to have to be made about how to implement it in practical terms.
And that was a matter for the discretion of the Secretary of State?
That's right,
And
in accordance with the policy. To be exercised in accordance with their stated policy.
I understand that.
Yes.
And that stated policy gave the Secretary of State
33 months.
Well, subject to the power to grant a longer period.
Correct.
It wasn't. It took 33 months and only. The Secretary of State had a general discretion. The policy was 33 months, but it may be longer.
The Secretary of State has the power to issue longer or indeed shorter, but the policy says that normally 33 months is the applicable amount.
I understand that. But it was only when the stamp appeared that the appellants would have known that in this case it was only 33 months.
That's right.
Seems a bit hard to think that time could have run from a tribunal decision which the claimants won. What would they have said in their judicial review application if they'd issued it in July 2017?
Yes, I mean what they would have had to say is the Secretary of State will issue us 33 months in accordance with the policy, the stated policy, and that would be unlawful because it's discriminatory.
But that would be in advance of the decision being made.
That is.
How could you do that?
Yeah, I accept that. Perhaps recasting it. Actually, the argument should have been making a submission to the Secretary of State in advance of the decision that in order to implement the decision, they should be granting the same amount of leave as they would do had they succeeded under the rules.
There are a number of possible dates. One is when they applied for entry clearance, because at that stage they were affected by the rules. But Badmus does say if there's a requirement that there needs to be a decision, and you would have to decide lots of facts, what are the relationships on. So you might not take the date of application.
Yes.
As at the next date, that's the first tier tribunal decision, that decides that there's no ability to satisfy the rules, the 12-month, the 18-month, or in loco parentis.
Yes.
There hasn't been any appeal against those aspects of the matter. There has been an appeal against the Article 8 findings when the FTT said, no, it's not even Article 8. So I could understand more as saying either it's the decision of the first tier tribunal, because that was the last word on the rules, or certainly no later than Mr. Justice Holman, who said the rules are all right, or possibly the upper tribunal later on saying it's common ground that the rules don't apply. There were a number of stages when it became clear that you would not automatically get the same leave as the sister, because that had been ruled out. There was a question as to whether there would be any reason not to do with compliance with the de facto adoption rule for getting longer than 33 months. And those dates come earlier, but it's hard to see the UTAC decision of all of them being the trigger.
Well, you have my submission. I'm not going to push further on that point. I think the point that struck us when we were reading Delve yesterday was at paragraph. So it's in the supplementary bundle, page 195.
Oops, sorry.
Yes. Paragraph 124, which follows obviously 123, where Mr. Justice Lang said, if proved, this was to do with pension.
Sorry, wait a minute, I'm not.
Sorry. Paragraph 123,
Yes.
on page 135.
Yes.
There's reference to the judge below, Mr. Justice Lang,
Yes.
holding that the claimants had established on arguable grounds that the implementation of the changes to their pension age was in breach of their legitimate expectations, and it had resulted in, and continued to result in age and gender discrimination. She said, if proved, these are continuing unlawful acts, and so in my view, the claimants are not time barred from challenging them in the court.
Yes.
And the Court of Appeal said at 124, we disagree with Lang J's analysis as regards the application of the time limit here. Unlawful legislation is not a continuing unlawful act in the sense that the time limit for challenging it by way of judicial review rolls forward for as long as the legislation continues to apply. If that were the test, there would effectively be no time limit, etc.
Yes.
And that was in the context of a challenge where the legislation was changed on one date, but the challenge wasn't brought until much later, when the claimants concerned would have become entitled to a pension. So it was a much longer time period. So it started us thinking, well, hang on, along the lines of what my Lord Justice Lewis was saying this morning to my learned friend. Well, the challenge is to the rule, and so it's the date of application, or potentially the date of the decision by the entry clearance officer who said you don't meet the requirements of the rule, which is why we suggested as the earliest date, actually the 7th of November 2012, which is the date of refusal. So it was in that context, while accepting that Badmus says that precisely when a person first becomes affected will depend on the facts and circumstances of each case, and that's Badmus at paragraph 17.
What led you to accept that the rule was relevant to the December 2017 decision?
I don't think that it had been reflected on in that way, to be completely frank.
But that was the consequence of your acknowledgement that that was the relevant decision and that the rule was relevant to that decision.
Yes. I mean, the case hadn't been analysed in the way that it has been explored this morning. Here was somebody who succeeded in their appeal on Article 8. Then the Secretary of State had to implement the effect of that decision, which she did, and applied the guidance granting 33 months. And so there is obviously a decision in December 2017, but I think nobody had actually thought about, well, what is the connection between that decision
there
and
was
the
a decision, but there's no basic, we have no, there's no, the only decision we can see is the stamp. So we don't know the reasoning behind it.
No.
And that's why I'm asking the question, because it might be that when the decision was made, this rule was taken into account when the decision was made, and thought, well, this is a relevant factor, we need to look at it, we need to apply it. We have no idea.
We don't know. There's no evidence about that either way.
But except the recognition in the Secretary of State's submissions that the relevant decision was December, and that the rule, the challenge to the rule, was I don't think it said anywhere that this is an irrelevant challenge because this was an irrelevant issue. So it was acknowledgement that it was a relevant issue to the decision.
Obviously, it's a matter for this court if you want to draw that inference, but the reality is that it wasn't analysed in that way.
But we do know, don't we, that nobody on the claimant side before the 12th of December 17 decision said you need to bear in mind that we're entitled to come in as de facto adoptees because the rule is unlawful, even though we can't satisfy it. It's not just an Article 8 entitlement we have.
You're correct in that. What happened, of course, was the first pre-action letter was on the 15th of February 2018, so approximately
Yes.
2 months after that decision, saying please reconsider and accept that. Reconsider the amount of leave that you granted, and because the rule.
So we know that your side started thinking about it after the pre-action letter.
Yes.
Eventually they did, but that's all we know.
That's right. I mean, if I can just ask you to turn up the policy itself, which.
But do we have any information from the Secretary of State about the decision-making process that led to the 33 months and the matters taken into account when making that decision?
No.
Well, again, I don't want to be difficult.
The policy, which.
Well, you have the policy. You do actually have page 578. I'm so sorry, Miss Broadfoot.
Sorry.
Always helpful to.
578.
Yeah. Because when they reply, and I don't know what it means, but it does appear to be evidence. It does appear to relate to them.
578.
The relevant UK VI department has confirmed that the Islamabad Chappie or Chapas went back to the relevant department, and that confirmed that leave was correctly issued, 35 months limited leave, as opposed to indefinite leave. The entry clearance was for LTR and not family reunion, and the appeal was on human rights grounds only. That's the most we get, and that appears to indicate they were looking at it from the human rights leave outside the rules thing. That's the only thing I can find at the moment. But yeah. You haven't referred to that as evidence, but perhaps I'm wrong to think that is evidence of what happened.
No, you are right. What I thought my lord was asking me was whether there was some sort of internal notes.
Well, no, actually, I was wondering whether there was anything advanced in opposition to the application. Well, which might include internal notes. In opposition to the application for judicial review, that reveals something about the way in which the decision was made or the factors taken into account.
I mean, what we do, there are two things to draw your attention to. The first is the policy itself, which I'll do in a moment, and the second is the witness statement, which is in the bundle at page...
Which do you want us to go to first?
The witness statement, page 77.
That first?
Yes, please. So this is a witness statement that was filed in respect of whether or not, although obviously the court will reach its own views, the April decision was a further decision.
Yes.
That was the function of it, because
right.
that was the submission originally being made. So Mr. Kramer, page 75, sets out at paragraph 4, on the 29th of June 2017, the claimants were successful for the upper tribunal, which we know, on Article 8. On the 29th of September 2017, solicitors acting for the claimants wrote a pre-action letter, dated, although the date seems to be not there, complaining that leave had not yet been granted. On the 11th of October, the respondent sent a response explaining the delay being caused by the High Commission. Yes. And then paragraph 5, on 12th of December, the claimants in this case were granted 33 months limited leave during. The grant of leave was in line with the respondents' leave outside the rules, family reunion and family life, private life and exceptional circumstances guidance. You have that guidance, although we'll turn it up in a moment. The grant of leave was formally issued by the referred caseworker, yes. etc. And then it explains that this is normal practice, that where entry clearance officers considers an application, entry clearance may require to be approved on compelling compassionate grounds. They must refer applications, yes. etc. So that's the evidence. That's the only evidence, other than the letter that my lord pointed out.
Before we leave that and turn to the policy, just I hope there might be something there. Do you know, and if you don't know, you don't know, whether the pre-action protocol letter that I refer to, complaining about the delay between UTAC and the stamp in the passport, whether those referred to the rule or to general matters, or do you not know, or do we not have them?
I don't have it, so I don't know.
You don't know. Okay, don't worry. No, if you don't know, you can't be.
We've managed to fish out other documents yesterday and this morning that we realised should be in the bundle.
Yes,
but not.
It should have been.
But not that one. So that's why we managed to come with some of the other missing documents.
So now you want to take us to the policy?
The policy, which is tab 2. So it starts at page 35, and it's page 60. Page 59, sorry, grant entry clearance outside the immigration rules.
Sorry, tab 2 of which bundle?
So it's the authorities bundle.
Oh, sorry, right, sorry.
This is December 2020, but you'll assure us it was in the same terms as 2018.
One,
okay.
I'll find the reference.
No worries, as long as it's the same. But it,
yes.
I hate to be grim about accuracy, but it's such a good idea.
You're entirely correct.
So which page?
I was asking you to turn up page 59.
Yes.
And if you look at the bottom, grant entry clearance outside the immigration rules, the title.
Yes.
In any case where, following referral to the referred casework unit, which you also saw in the witness statement, the RCU caseworker decides appropriate for entry clearance on the basis of the applicant's ECHR, Article 8 family life, and exceptional circumstances with compassionate factors, this should be granted for 33 months and subject to a condition of no recourse to public funds. And then, for completeness, if you look at paragraph at page 61, there's a heading allowed appeals. The last paragraph, the only exception to the above, which doesn't apply, is where an appeal is allowed on human rights ground and the immigration rules have not been met, which is this case. These appeals must be implemented by the referred casework unit where the guidance is available. The appeals.
So that's the who is to make the decision.
That's right. And
yes.
And so
by definition, the fact it went to the referred casework unit meant that it was a case where the immigration rules hadn't been satisfied.
Yes.
And it was being dealt with other than under the rules. By definition, is it? If it goes to the, yeah.
Yes, that's right. So the fair inference from the material that we do have is that this was, if I can put it this way, a straightforward application of the guidance for granting of leave outside the rules, because that was the basis on which they had succeeded in their appeal, it having been found that they couldn't meet the requirements of the rules. And the period of grant is normally 33 months. And so what we say is, in answer to the question asked of Moylan and friend, the question was the rule, the immigration rule, so Rule 309A, applied in 2017? And Moylan and friend says, yes, it was, but actually we submit it wasn't. What was applied in 2017 was the policy that allowed appeals on Article 8 grounds are granted 33 months. That's what was done in 2017. I mean, if I can then turn to timing and the good reasons for the delay, in our detailed grounds, and none of this is in issue, and the cases aren't even in the authorities because of that, we understand they're not disputed. We set out the authorities on good reason for delay and extension of time principles. That's on page 51 of the bundle.
5.1.
5.1, yes. My learned junior, Miss Patchy, has just given me a note and said she's managed to find electronically the pre-action letter of the 29th of September 2017. So this is the one before the grant of leave in December, and it doesn't refer to the rule or the length of time to be granted at all. What it does is it says, we've been waiting for ages, if I can paraphrase, could you please get on with it and issue the entry clearance?
It might be helpful to have a copy of that at some stage.
We'll arrange that.
Yes, thank you.
Can you email it and something? Thank you. So I was then turning on to the question of extensions of time on the assumption that the court says it will proceed on the basis that December 2017 was the relevant date, or at least hold the respondent having taken that position. The principles are then set out, so at page 51, paragraphs 9 through to 12, which goes over the page. And obviously, I would specifically emphasise paragraph 11, which is again not in dispute, that is well established that reliance on the fact that it was pre-action correspondence does not extend time is not a good reason.
Yes, but that depends on the correspondence.
Of course, I entirely accept that. And so, if I could just say,
do you accept it would have been that it was reasonable not to commence proceedings between the date when they received your letter saying here's guidance on its way, don't issue in the meanwhile, and the response which subsequently came, or should they have issued proceedings notwithstanding what you said in your guidance letter?
They should have issued proceedings on the last day of the 3-month period, and then the Secretary of State could have had no objection to that and say they couldn't have said it wasn't brought promptly at that point, given that we'd said wait. But everybody knows in this field that the time limits cannot be extended by agreement.
But not that they know. I mean, the rules say they can't be extended by agreement. The rules provide specifically.
The rules provided, but also everybody knows. I mean, it's not a new rule in that sense.
So when the letter was written saying, we hope this negates the need for proceedings, why might that letter have negated the need for proceedings when all that was said was that guidance was being sought?
Perhaps the writer was hoping to get a response very quickly.
No, why did the letter itself potentially negate the need for proceedings?
Oh my lord, I think you might be reading the letter from a caseworker in a statutory type way. I mean, what they're really saying is, hopefully you won't issue.
So, somebody from Afghanistan who's come to this country and is told by a government official you won't need to act, needs to be careful, because they either are misleading or they haven't a clue what they're doing. Is that the submission?
No, the submission is that a solicitor at a well-established firm who's been instructed since 2017, because of course this was the second, there was the pre-action letter back in September 2017, should have known what he was doing.
Should have known not to take that at face value.
Should have known that if they didn't get a response within the outer time limit, because of course they sent the pre-action letter about 4 weeks before the time limit expired and got should have known that the time continued to run.
Might that be called a bit of a trap? You needn't do anything, and then when you don't do anything, oh, well, sorry, time's expired.
Wow.
I mean, in general civil litigation, I think it might be viewed as a bit of a trap. I think what my lord is suggesting is that when a government official says something, it might be placed at a higher level. Appreciate your point about solicitor on the other side. And that's why I was asking you what was meant by negates the need to bring proceedings. And your submission is we just have to read the letter and take it as it's...
That's right. That's right. And turning to the factors in the good reason, on the one side, in the claimant's favour, there's of course the terms of the letter saying please wait, and I accept that that is a factor that is relevant, and that the solicitor in question made a mistake. That was the other point. And then of course there's the finding by the judge below that she accepted that he acted in good faith. And there was a question about, well, what did she mean by that? And in my respectful submission, what she probably meant is in response to the order of Deputy High Court Judge Mott QC at paragraph 5, which says in its second sentence, or third sentence, instead, rather disingenuously, the claimant's solicitor seeks to rely on a decision of the 26th of April 2018. So there's quite a strong finding, or certainly observation, by that judge. And in my submission of fair reading is to say, well, actually he wasn't being disingenuous.
So the good faith goes to, I understood that the 2nd April letter was the relevant decision.
Yes. But then on the other side, then what you have, of course, is you have the letter of the 26th of April, and what happens then is that, notwithstanding the order of Deputy High Court Judge Mott in November 2018, no application for an extension of time is made until either the day of or very shortly before the hearing on the 26th of September 2019. By which time there were summary grounds taking the time point on behalf of the Secretary of State, and I also believe a skeleton argument, although I don't have a date of that.
Is this the one for the commission hearing?
Yes.
Just out of curiosity, is it a landmark thing? Neither your skeleton in this case nor the other skeletons have been dated. I was sent 3 skeletons, and because they weren't dated, it was very hard to know without reading all 3 whether they were the same or different.
I apologise, that's not my practice. I normally always put the date, and I didn't notice what
right.
I'm sorry.
Anyway, you want the one, I think the one
So
at first instance is...
the one at first instance.
Sorry, I'm rather behind. What page? Where are we going to?
We're going to the skeleton argument that was lodged before the High Court at the Commission hearing. It was just to show you.
But which bundle?
It'll be, I'm just finding the page reference. It is.
Is it the one at 485? No, not quite. 482, I think. Or is it not?
482 is the Secretary of State's skeleton argument.
I think the note's being passed to you.
Thank you.
Actually, that one is dated 23rd of September 2019.
Yes.
So Miss Patry does put a date on.
It does. Anyway, the only point.
Sorry,
shown,
which page are we?
So it's page 489.
Yes.
And paragraph 13, just above it, extension of time, the facts of the present case, and then there's a whole submission. There's a whole submission about time. It is the point.
Sorry, what was the point?
So what I was doing was putting facts on each side
Yes.
of the scales in relation to good reasons to extend time.
Yes.
My submission was that a factor that counts against the
Yes.
extension of time
Yes.
was the significant delay between the time period, the delay being pointed out in Deputy High Court Judge Philip Mott's order in
And the
November
application for
2018,
an extension.
and the application extension, which was made nearly a year later, nearly a year after that, and just before, or on the morning of, I can't quite recall, the commission hearing.
Yes.
And so that was the point, and showing you the skeleton.
It took a year to get from the paper decision
to an oral
to
hearing.
the oral permission hearing.
It did. But when one's considering things in the round, that's a factor.
Yes, I think there's an application for an adjournment because of regulatory difficulties, but I'm not sure if that's correct. I think the claimants applied for adjournment, but again, that may be incorrect because there's no clear. You try to work it out from the bundle.
We'll check.
Chair, I think that's right. It doesn't matter. It was a year anyway.
I think that may be a fact.
So the skeleton was dated the 23rd of September 2019, which clearly takes the time point. I suspect it's also, I need to double check whether it was taken in the acknowledgement of service as well. And the hearing was on the 26th of September. And it looks like the application notice was filed on the 19th of September, so just before the hearing, although I think that Ms. Patry didn't actually see it until very shortly before the hearing and after her skeleton had been drafted and filed. So that was the point about ongoing failure to deal with it. And then finally, of course, we've got the time in any event from 26th of April through to the date that the claim was filed, which is, I think, the very last day. And there is clearly a lack of promptness in that regard, especially given that it is now conceded that, at best, the decision to be considered was December the previous year. And my junior is just pointing out that the point about timing was taken in the acknowledgement of service as well, and that's page 507.
Five 507.
507, just the 11th of October. Thank you. Right. Yes. So the time point was squarely taken in the acknowledgement of service, which was filed on the 11th of October 2018, i.e. even before, as you would expect, in fact, the order from Judge Mott. So those are the points for and against the balance, if I can put it that way. Can I turn very briefly to the other points that my learned friend raises? With respect, we agree that prejudice may be a reason not to grant an extension of time, but its absence is not it doesn't work the other way round. So we agree with that submission, and of course, prejudice. I mean, there's general prejudice, as there always is when things are
Yes.
late. In relation to significant impact, the position currently is obviously that all the appellants are in the United Kingdom. They have had further decisions which in fact have been refusals, so they'll have to appeal those, but will remain in the United Kingdom in the meantime. And of course, 8 of the 11 are now adults. And the finding...
Yes, and the significant impact, I think, advanced by Mr. Bewley is the difference between 33 months and indefinite, and the consequences of that.
And there is a difference, of course.
And so the impact of that difference could be described as very significant.
Yes, I agree that there's a difference. It's obviously a lesser form of leave to get 33 months than it is to get leave in line with the sponsor.
And did the sister, just remind me, did she have indefinite leave to remain?
No. I don't know whether she has it now, but
at the time.
Had the rules already changed?
She wouldn't have had it at the time of the application. She got it later. She's now British.
Right.
No, but what at the time? What did they have?
At the time of the application, my lord, she wouldn't have done. If I can just briefly add one thing to that, so the court understands. No, what she would have been by virtue of the kind of leave she would have been granted would have been on a path to settlement.
Yes.
So, albeit she wouldn't. She didn't have indefinite leave at the time. She could have expected to, and indeed
was.
What
did she have is the question, not what she might have had.
It would have been 4 or 5 years. I'd have to.
4 or 5 years.
We'll get the precise.
At the end of which.
At the end of which she would have been entitled
to apply.
Exactly, and so the significance of leave in line is that the then children would then have been in the same position.
Because once you've been resident for 5 years, you could then apply.
Yes, and indeed they would have, I think I'm right in saying they would have been entitled to apply at the same time as the sponsor. They wouldn't have had to wait for their own 5 years. So rather than have everything thrown up in the air again every 33 months, you get that. So
there's a path to settlement for both. None of them get indefinite leave. It didn't clear to me yet, and it might be relevant, because if it's 4 years, she'd have to apply again. If it's 5 years, unless the rules had changed at the material time, she could have applied to be a British citizen after 5 years. And you haven't given us any of the facts of your client's case.
Well, it's 5 years refugee leave. Could she apply for citizenship immediately? Yeah. So, my lord, it was 5 years. She wasn't. I'm being told. I mean, she wasn't then entitled to apply for citizenship immediately.
So she herself had to apply for discretionary leave.
She had to get indefinite leave, and then she was able to apply general life.
You're going to get ILR before you get citizenship.
At least in this instance.
So it was 5 years, had to apply for ILR, and then she'd have to apply for citizenship.
Yes, but I mean, I don't want to labour the point. But the significant point is it's not just a difference in period; it's on the path. It's the path to settlement.
It's the pathway to permanent settlement.
I've got 2 factual points. Is it?
I'll do my best.
You've made points about about fees. Yes. Each of the 11 applicants, and presumably the sister, had to pay fees. There were 11 applications here. Were the fees waived or not?
The fees were waived.
So the fees were waived.
On the facts, yes.
So in fact, there was no differential treatment there. And so far as the condition for no recourse to public funds, I've seen a reference to an application being made to remove that condition from their discretionary 33 months leave.
Yeah, I'm just double checking. That hasn't been lifted.
So the no recourse to public funds hasn't been lifted.
Hasn't been lifted. And just to make the point about fees, it's right that the fee was waived, but of course that's an issue that comes back every 33 months. So
I understand that. It's not. You keep looking at what might happen if.
No.
At the moment, because I haven't got all the facts in the bundle, I'm just trying to establish what the facts are. And it's very unhelpful when you try to establish what the facts are, to avoid a clear answer on that by saying what might happen if. And the fact is the fees were waived.
On the facts.
But the no recourse to public funds condition was not waived.
Correct.
For any of the 11.
In relation to no recourse to public funds, we're going to check, but it's our understanding that that application wasn't made to remove it.
That may be right.
So that's currently our understanding, but we will check that.
Okay, thank you.
finally, on the important public law point, I don't have a great deal to add to what's already been said by the court about the overall merits. I mean, we did question the findings that had been made below, and I think that's paragraph 18 of our skeleton, where we say, well, hang on a minute, it doesn't look like the 18 months requirement is met. We didn't, to be fair to my learned friend, challenge the point about local parentis, because although the finding in the first tier tribunal is clear that they find that it isn't loco parentis, on reading all these subsequent decisions, it was not entirely clear to us what really the finding was ultimately, because of course by that point everybody was focusing on Article 8 and family life.
It seems to be that it was not a de facto adoption, but that overlooked from the family life perspective. These 11 children had nowhere else to go, were being looked after by the father. He couldn't come back and live with his wife because she was in England because of leave.
To do that,
but there's nothing to say that there was a finding that they would have met the genuine transfer of responsibility for de facto adoption. But what was criticised was the failure to realise that wasn't an answer to the degree of family life for Article 8 purposes. Seems to be what's in the bundles when you read it.
Yes, I entirely agree with that. Although it seemed that it wasn't. There's absolutely no clear finding the opposite way from what the first tier tribunal said, but that would be because by then everybody had moved away from Rule 309A and were focusing simply on Article 8, and so it seems that at best that may be unresolved.
Do you have anything to say about Mr. Bewley's submission that it's in your client's interest to have at least the 12 months point decided?
Well, I mean, there's always obviously interest in having the law being clear one way or another. However, what we should remember is we are in the Court of Appeal and there has been no substantive hearing at a lower level. And it would have been our preference, had the matter proceeded in a slightly different way, for the matter to go to the High Court to have...
No, you would object to what's called a rolled up hearing, and you would say, well, if time was extended, it should go back to the High Court for a full hearing.
I would say that. I mean, I didn't feel able to object to the courts who decided we were going to have a rolled up hearing.
No, but it wasn't. It was left open in the directions. It was up to this court to decide what the process would be. But my Lord's question is a different one, which is what you say about the submission, that it's in the public interest, in the Secretary of State's interest, that this issue be resolved.
In my submission, it is in the... It may well be in the interest, but in a case where all the relevant facts have actually been found, whereas that is not this case.
Not yet this case.
No, that's right.
But it might be this case if it went back for a full hearing.
It couldn't. I mean, unless the High Court was going to exercise a fact-finding jurisdiction in that first instance. I mean, the reality is that it would be much better for this point, if it is to be determined, bearing in mind that this rule has existed for 20 years nearly, and has been being applied and was litigated back in 2006, 2007, and but only at upper tribunal level. But this rule has stood for a long time, has been applied, and consistently, and so certainly the Secretary of State doesn't feel the need to have it.
But you say it would be much better litigated at first instance, not here, and therefore in a new case where it arises for that case.
Yeah. Absolutely, not in this case. If I could just turn my... Thank you. So we object to the extension of time and those are submissions.
No? No? Yes, Mr. Bewley.
I'll be relatively brief. I can see the time. Can I just pick up on the exchange a moment ago at the start, which is the possibility that the court might deal with this, and I make no assumptions about it, but by extending time, but then by remitting to the High Court. I'm conscious that we've spent the morning on the delay issue, and that may in practice impact on the court's ability to hear the matter if time is extended. So it's not a matter to which I would have any objection, or indeed I can see the attraction of it.
I can't see how we could begin to
No,
address
I do follow that.
issue.
I do follow that completely. Can I just say on that, I won't take you to it, but in the permission skeleton, we did draw the permission judge's attention to the possibility of the court hearing the matter itself. We did actually say we thought it would be better for the High Court to hear the matter. Now, I obviously, like Miss Broadfoot, having seen Lord Justice Hickenbottom's order, we didn't see any progress to go behind that. But since the matter now arises again, it's not something to which we have any objection. We can see the sense of it, certainly at this stage of the day.
When that order was made, he obviously had no appreciation of how this hearing might develop.
Exactly.
And I think, having regard to how the hearing has developed, I think, I also haven't spoken to my colleagues yet, but I think it would be difficult to acknowledge, other than that we're not in a position to go through the remaining 2 bundles of authorities.
Yes, and I completely see that. So if I mean, I'll make my submission now in reply on the extension of time point, but it seems to us, bearing in mind practical difficulties, that would be an attractive course, and it would mean that the time taken this morning, I don't make no complaint about it, won't itself become a barrier to hearing the matter properly. So, my Lord, as to reply, can I just pick up a point? The court will have this, I think, and has already referred to it, so you needn't necessarily turn it up. But my learned friend made a point about the order of Mr. Mott, Queen's Counsel, that he had referred to reliance on the April letter being disingenuous.
Yes.
I mean, the short point about that is one I think the court is alive to, which is that when Miss Obi considered the matter, not in a superior capacity, but generally the findings of the oral hearing judge would take precedence, she accepts, the court knows it's paragraph 6, I'm happy, and it must relate to this point, I'm happy to accept the claimant's acted in good faith.
Well, and that was the point, I think, the submission being made by Miss Broadfoot. That's what the good faith observation was directed to.
Absolutely.
Yes.
So I don't accept, insofar as it's being said, that there's something about Mr. Mott's order that a factor here is we didn't act in good faith, or those instructing me at the time didn't act in good faith. Well, if that submission wasn't made, I can see the heads being shaken. So be it, I misunderstood. So I just deal with that. My Lords, you have the thrust of my submissions. Can I just briefly reprise them, and hopefully without repeating?
We don't need to reprise them. We've got them.
Sorry.
Have you got anything to reply?
Just touch on each of the headings then, by way of reply. My Lord, critical point, starting point, as I started in my opening on this issue, is the correspondence in the, I'll call it the winter of 2018. You've seen it, I won't go back to it now. My learned friend says in relation to that, look, everybody knows, and it's probably right, people know, operating in this jurisdiction know that you can't extend the time limit by agreement. That's true. And that if you don't act within the 3 months, you run the risk of the court saying you're out of time. That's true. But the question is not, was the time limit extended? We've never suggested that it was. The question is, in circumstances where correspondence is written in that way, is that a good reason?
Is it relevant to the discretion rather than the
that's the way we put
time
it.
bar? Yeah.
And I say, with respect to Miss Broadfoot, I don't accept that she answers this. And she does, in fairness, accept that it's a relevant factor. But it's really a very powerful factor on that basic question of extension of time, at least beyond the 3 months. And so in those circumstances, in my submission, the starting point really has to be that time should have been extended on that basis alone. And the question, and I see I'm in slightly greater difficulties on this, I've acknowledged that, the question is, should it be extended quite as long as we're asking for, to July? Now, as to that, I then point to the other factors that I've alighted on, which the court is. So that's the structure. Should time be extended to at all? Well, yes, plainly, with respect, plainly so, for that reason. Should time be extended to the degree we are seeking? I'm thinking really about the December 2017 decision of the state submissions. Well, it should for the reasons that I've outlined. But in particular, my lord, I do press upon you the 2 points: the significance of all of this for my clients, which is very severe for the reasons I've given. I won't. My lord.
Mr. Wheatley, this, from a lay perspective, will have seemed a very dry legal.
I'm conscious of that.
Debate.
Yes.
But of course, we are very, very well aware of the underlying situation that your clients are in.
Yes.
So
Well,
I wouldn't want anybody.
I know that, but it's if
No,
I may say so, it's a good thing that your lordship says so.
Yes, I
openly.
appreciate why you're making this submission.
Yes.
I'm making
You're alive
replying
to the
to
point.
it
Yeah,
by
sure.
saying that we are, of course, very conscious of the underlying circumstances.
Well, my lord, I won't go on about them, but I hope I mean the relevance of the point here is to the court's discretion. That's why I
Yes.
And it is in my submission a very significant factor, and it is a very significant factor in the context of the dealings from 2012 onwards. It would, I suggest, even leaving aside the public interest points, assume for the sake of argument, as one must at this stage of the argument, that we've got a correct or arguable case. It would be an injustice, a genuine injustice, and the court can take account of that my clients should be denied the benefits which we say they would be legally entitled to, not having breaches their human rights. If the delay of, I suppose, some months between, say, May and July were to lead them not to get the benefit of those advantages. That brings me to the. I've been given a note which I can't read. Can I just have a moment? Sorry. Yeah. Well, we made the point, and we made the point in terms. I'm so sorry. I'm so.
You've got a meeting.
I'll wait, and then I see my lord's
Right,
hands
no,
up.
my Lord Justice Males has got a meeting at 15:15, so we are.
Right. Well, let me. Shall I just? I can see my Lord Justice wanted to ask a question. I don't know if.
No. I was trying to stop you speaking.
Oh, you were
whilst
warning
the
me
other
off.
two
I'm
weren't
so sorry.
listening.
Thank you. Yes, I'm grateful. Thank you. Right. You have that submission.
I don't want to stop you saying anything that you need to
appreciate
say. And if you say better
one
rise
last-
now and we'll come back at 2:00, then we'll do that.
My Lord, there's a single last point.
Right.
The additional element is the public interest. My learned friend says, well, this point has been litigated previously, but with respect, it hasn't. Issues around these rules have been litigated.
Lawfulness has not been litigated.
Well,
and couldn't have because they were statutory appeals.
That's correct, but also the specific problem. That's right, and also the specific problem faced by refugee applicants has not been litigated, which is what this case is about. So SK, which is referred to, I won't go to it. It was about a slightly different issue concerning Rule 309A. It wasn't about this specific issue, and you have the evidence that, the 20-year point. Look at the evidence, please, of JCWI about the numbers of people affected by this rule in very severe ways. Some of whom would not have been in a position to bring the matter to the court. Certainly, if we're right that you don't challenge until the end of the process, because the tribunal doesn't have jurisdiction to deal with it.
Thank you.
And in those circumstances, powerful public interest. Those are the submissions. I hope that doesn't trespass upon the court's
We're
time.
going to rise for a few minutes.
Yes.
And so please don't go away.
I moved. So I thought we had a discussion.
The thing is, right, I told you to sit there, now my manager's going to see some pictures
Depends when it
and she's going to explain these, so I'll ask her to get in touch with you. But you want to sit there.
Yeah.
So if you choose to sit there, it's up to you, but I'm going to try to get in touch with you.
It was on the same before. I mean, that's not me getting a you. I'm just like so nasty.
We're just being told off about sitting in this row.
Oh, and didn't raise it. Well, I had quite.
You know,